Hello and welcome. You tune into Buy Now Sell Now with me, Ankita Saxena and Kanishka Sarkar. This is a show where we get all your questions answered. But before we get started with the show, there's a big breaking that we are tracking. Supreme Court has upheld JSW Steel's acquisition of BPSL and the resolution plan of Bhushan Power that has been upheld by the Supreme Court. Let's go across to my colleague Prakash Pridashi, is now joining us with the details of this big breaking. Prakash, take us through everything that you've got.
It's a very significant development coming in, a very positive development for the JSW Steel as well. The Supreme Court has upheld the resolution plan for JSW Steel Limited for Bhushan Power and Steel Limited, with an approx rupees 20,000 crore. The Supreme Court has rejected the objections raised by the ex-promoters and certain creditors of BPSL. A bench comprising Chief Justice of India, B.R. Gawai, and some other judges had reheard the appeals against the resolution plan after recalling judgment delivered by two judge bench. A very significant development coming in. That essentially means that JSW Steel can retain the control of a company, and at the same time, lenders will not have to face a hit of approximately 34,000 crore. You were aware that the review plea arose after Supreme Court's second May ruling, where JSW Steel's resolution plan of BPSL, which was resolved at around rupees 20,000 crore. And then, after order of this liquidation of BPSL, a lot of concerns were raised by the government as well. In fact, the government of India was of the opinion that it could have significant implication on overall IBC process. And therefore, there was several review petitions before the Supreme Court to hear. And now, the final verdict has been delivered by the Supreme Court. That essentially means it's a very positive development on the overall framework, positive development for the insolvency and bankruptcy code framework as well, as this acquisition was one of the biggest resolution under IBC. Therefore, Government of India must be very relaxed at this point of time, because the IBC framework is something being considered as one of the biggest governance reforms, corporate governance reforms in independent India. And therefore, after this judgment, the overall insolvency and bankruptcy framework will continue as it was earlier. Back to you.
Thanks, Prakash. We have Mr. Sumant Batra, Managing Partner Head Insolvency Practice at Kesar Das and Associate. Mr. Batra, do you think that it gives you a big boost to the entire IBC process because it put the entire thing in question after the Supreme Court or the Apex Court, ruled in May that the entire process was not as per conformity?
Well, yes, of course. More than it bringing relief to JSW, that its resolution plan has been affirmed by the Honorable Supreme Court. What it does is it brings a great amount of respite to the market, to the investors, and of course also to the government, because that judgment had in fact created a kind of a disruption and created so much of uncertainty around the IBC process, because a plan that had been approved 4 or 5 years ago and had been partly implemented was sought to be set aside on certain aspects, which the review judgment has clearly held that was an incorrect view. So it's a remarkable judgment. It is restoring the confidence in the IBC, and it will go a long way in reaffirming the faith in, as was mentioned by your colleague, what is the blue chip reform since independence in the independent India.
Just hang on there. We have Mr. H.P. Ranina as well, lawyer and senior counsel at Supreme Court. Mr. Ranina, it's very rare that the Apex Court goes back on its own verdict, and this time it has done that in the IBC. In May, it ruled the entire process of Bhushan Steel as not per conformity, and then went ahead and allowed the review petition, and now going back on its own judgment.
So I think it is a good decision. Supreme Court also reviews its own decision if certain implications are pointed out to him. And this time it was pointed out that if you go into liquidation, there'll be a lot of complications, a lot of things will have to be overturned, a lot of employees will lose their jobs, financial institutions will not be able to recover their funds. So it is best for the merger to go ahead. And therefore, this is a very landmark decision, important historic decision, because it will mean that it will apply as a precedent for other situations like similar situations where mergers have been approved. So I think the reversal of the earlier is a step in the right direction. It shows that the Supreme Court is always responsive to the very good suggestions, and if they are not frightened of fear reviewing their own case. So review is a very important point which the Supreme Court has, and they've exercised that power in this case because it is a very appropriate case to do so.
One important thing is that the kind of observations that it made in the May order when it ruled in against JSW Steel. Do you think that even though the Supreme Court has gone back on that order of on the entire IBC process of Bhushan Steel, there are the observations which have been made by the Supreme Court will have now to be put in place so that a process is followed while an IBC is undertaken? Mr. Batra?
Is that? Is that for me? I didn't realize that.
Yeah.
Well, we still have to read the fine print of the law, because once we get our hands on the copy of the judgment, we'll be able to see whether the observations made against the COC, the RP, and some of the other players have been recalled. But what I heard from the concluding paragraphs that were read out by the Honorable Chief Justice in court, it appears that the Honorable Supreme Court has, in this judgment, reaffirmed that everything that was done by the COC was in order, and clearly both the SRA and the COC were very diligent. They were taking all the steps that was expected for the implementation of the plan, the speedy implementation of the plan. And from all that I heard, it appears that they have disagreed with the observations by the two-judge decision earlier. But I also see that besides, of course, making the corrections in the earlier order, they've also made a couple of other observations which will probably have a significant impact on the functioning of the IBC, although positively. But we'll have to read the fine print again, as I said, because they've said that the COC should continue to function even during the implementation of the plan, and or till the liquidation order is passed. Now, which means that they've expanded the role of the COC beyond just the stage when the plan is approved, but also have gone to the stage where they oversee the implementation of the plan, which is contemplated to be done by the monitoring committee earlier. So we'll have to see, once the judgment is copies available, as to what other observations have been passed by the Honorable Supreme Court.
Mr. Ranjana, do you concur with what Mr. Batra is saying, that the role of CEC is now being expanded to monitoring of the entire or execution of the plan which is there, and thereby it has a much wider role at play now?
Yes, I entirely agree with what he says. We have to see the judgment. But normally the final judgment prevails over the earlier one. So, but of course, unless they have made other comments, the original comments will continue. So whatever is done will continue. And therefore, we have to read both the judgments together and see how it works out. Because if this particular latest judgment gives us a different view, then of course it will overrule the earlier one. But if there's no comment in the latest judgment, then the observations in the earlier judgment will continue to apply.
One of the biggest criticism of the entire process is that normally it should have been completed in 180 or 6 months or so period, but things are dragging on at IBC and resolutions are not coming through. Do you think that it will put in some kind of process in place for the faster resolutions of companies going through the IBC process?
Yes, that is something which the NCLT should do itself, because they were to set their own house in order. The problem with them is there are too many pending cases and there are too few members on the bench to hear those cases. So it's a very difficult situation. You can't blame them for the delays. Delays have to be sorted out at various levels where you have to have additional benches, additional members appointed, additional infrastructure, and then only the delays can be taken care of. Otherwise, the delays will continue.
Mr. Batra, one of the feedbacks that come in is that the kind of powers that is imposed by the COC on the entire process. Do you think that the current Supreme Court judgment brings in some kind of formality on the role of COC and the kind of powers it has with respect to the entire IBC implementation and execution of the entire plan?
Well, the role of the COC in order to exercise their commercial decisions and the authority that they have, the powers that they have, I don't think anybody questions either the Honorable Supreme Court or the law itself or IBBI or even the market. I think the only debate has been that those powers have to be exercised with care and responsibility. And there have been certain instances where certain decisions by the COC have been subject matter of scrutiny. And that's the reason where the Standing Committee of the Parliament had 3-4 years ago in its report recommended that there should be a code of conduct for the COC members. And which is what now is contemplated even in the bill that has been tabled in the Parliament on 12th August to amend IBC. But the debate still would be whether that code of conduct should be voluntary or imposed in the regulations by the IBBI, because there could be a bit of a pushback by the lenders to say that we are, we are regulated by RBI and not by IBBI, and therefore, even if it is the decisions taken in the COC, that can't be questioned by IBBI. That I would say is an issue that is still up in the air, but there's no doubt at all that the COC will continue to play a very important role in the IBC, except that they need to be far more accountable, and it should come through self-regulation rather than somebody breathing on the neck to say do it this way or that way.
Thank you, gentlemen, Mr. Batra and Mr. Ranina. Thank you very much for joining us today on ET Now. And